Hey everybody, it is Our Trades back here with another video. It is July 3rd, 2025. Guys, we're going to be talking about the Topstep Patrick Wieland lawsuit today. As many of you are aware, I'm a licensed attorney here in the state of Texas, and it's not often that my two favorite things, lawsuits and trading, I get to talk about both of those things combined. So we're going to go over a little bit of drama today. Before I get into this, guys, I first want to let you know that I'm no longer affiliated with any prop firm. So please follow on X, like on YouTube, that sort of thing, but I'm not going to be selling you a trading prop firm affiliate. I do still trade. I trade micro futures on my own account. Also, guys, a couple of disclaimers here. I'm going to go through the lawsuit. I'm going to go through the face of the document. We're going to read it. I'm going to give you some of my thoughts. I am not a licensed attorney in the state of Delaware. I'm also not a licensed attorney in Hawaii, California, or Illinois, which also seem to be kind of involved jurisdictions. I'm a licensed attorney in the state of Texas. By making this video, I am not providing any commentary that should be interpreted as legal or professional advice. And of course, guys, I can't offer legal or professional advice in those states that I am not licensed. So when watching this video, it should be used for entertainment purposes only. Okay, guys, so as many of you are probably aware, there's been a lot of developments in the prop firm space recently. And because of those developments, in part, I have decided to move away from trading with prop firms altogether, just trade micro futures on my own account, which I like doing anyway. So not a big deal for me. Of course, guys, as you know, I'm not a professional day trader. I'm an attorney, so I day trade for fun. Day trade as a hobby. I'm certainly not a professional day trader. But there's been a lot of developments where Topstep, for example, no longer has any other platform than Project X. Trade came out and slammed Topstep. Apex has had a lot of drama recently. Top One Futures had a lot of drama, and there's a lot of, obviously, drama between Patrick Wieland, who's an X or social media prop firm influencer, media personality, and Michael Patak and Topstep Trader, which is one of the largest or leading prop firms in the industry. So with that being said, guys, let's first have a look at who the players are. So this is Patrick Wieland. He's, if you're in this space at all, you definitely know who this guy is. Big-time YouTuber, live streamer, media personality. Trades with Apex now, used to be affiliated with Topstep. And this is what he looks like here. I'm not going to play any sound on this video. This is what he looks like. He's out on a boat right now. Looks like he's having fun. Anyways, I personally have nothing against Patrick Wieland. And by making this video, I'm not saying that, I'm not inferring that I do. Oftentimes when you're going through a lawsuit, you're just kind of reading one side of the equation. Patrick Wieland has not filed a response to this lawsuit, but let's get into who the other side of the lawsuit is. So this is Michael Patak. I think he's probably in his mid-30s, early 40s, founder of Topstep. Maybe he's in his mid-40s, early 50s. I guess he might be a little bit older than what I'm thinking. So anyways, he's the CEO of Topstep Trader, which is the entity that is suing Patrick Wieland. So with that being said, those are your players. You're probably already familiar with who those players are. And let's have a look. All right, guys, so this is, as you can see, e-filed, which this is called an e-file stamp, and it will tell you the clerk and the cause. He filed on June 30th, 2025 at 11:48 Eastern Daylight Time in the Superior Court of the State of Delaware, styled Topstep LLC, v. Patrick Wieland, cause number 925C-06. We can see that it's entitled Complaint, which is, in Texas it would be called a petition. In Delaware it's called a complaint. Federal court it's called a complaint. But it's the document that starts a lawsuit. So if you're wondering what actually initiates or starts a lawsuit, it's called a complaint. In some states, it's called a petition. In Texas, this would be called a petition. All right. So we see first here that the plaintiff is Topstep LLC, by and through its undersigned counsel. That's going to be the law firm that's retained. Hereby states and alleges as follows for its complaint against defendant Patrick Wieland. And you can see in these parens, that's going to be they're going to be referred to as Topstep and Wieland in the future. All right, guys, first heading, nature of the action. Topstep brings this action to address Wieland's, the self-proclaimed #1 futures day trader on YouTube. He does, in fact, call himself that. Brazen and intentional breaches of a March 29, 2024 settlement and release agreement, which will be referred to as the settlement agreement, under which Wieland accepted hundreds of thousands of dollars in exchange for his promises not to disparage Topstep, that shouldn't have a possessive, and to keep confidential certain information relating to Topstep. Worse yet, Topstep and Wieland only entered into the settlement agreement because of Wieland's past smear campaign against Topstep, forcing Topstep at the time to terminate its contract with Wieland for cause. All right, so let's break down what some of this means, and kind of, if you're wondering what does all this mean, it seems like legalese, I'll try and break it down for you. So let's first talk about Topstep brings this action. So that basically means they're filing a lawsuit. What is this intentional breach of a March 29, 2024 settlement and release agreement? So I don't know if we have attached a copy of a settlement and release agreement, but guys, long story short, what is a settlement and release agreement? Typically, when 98% of civil lawsuits, just like this one will, 98% of civil lawsuits on average will settle. So typically that means one party is going to pay a sum of money and the other party is going to be released from a claim. That's how 98% cases of civil lawsuits over damages, money damages, 98% of these things settle. So when you reach a settlement agreement, that agreement will be, for example, I'll give you $5 million. In exchange for $5 million, you release and agree to forever hold me harmless from certain incident. In addition, there may be certain terms in those agreements for, usually you're going to have what's called a confidentiality or a non-disclosure agreement that basically says that the terms of the settlement agreement are to remain between the parties and their counsel. That's a standard provision in most settlement agreements. Now, you're also going to have what's called an agreement not to disparage or a non-disparagement agreement in most settlement agreements. So what does that mean? Non-disparagement agreement basically means that you aren't going to go out and speak badly publicly about the other side. You can understand why a lot of companies and a lot of defendants in general or people that are settling lawsuits, these things often get really emotional where the two parties really don't like each other. And if you have a party that wants to protect its image in order to go ahead and settle that claim so you don't have to move forward with years of litigation and trial, you want to include that agreement not to disparage. So that's what a settlement and a non-disparagement agreement is. Okay. And then what does it mean to terminate its contract with Wieland for cause? Basically, when you enter into a contract with an employee, there will be either what's called termination without cause, meaning for any reason whatsoever. Most right-to-work states, you don't have to have cause to terminate someone. But then there's terminations for cause. So if you have a contract with someone, cause for termination will usually be listed in that employment agreement. Smear campaigns, disparagements, that sort of thing are typically, especially in a marketing and branding deal, you're going to have an agreement where your contractor cannot besmirch or disparage the company that is contracting. Okay, so that's pretty standard in an employment contract or an independent contractor contract. Number 2, still obsessed with his personal vendetta against Topstep, Wieland continues to A, disparage Topstep, although he agreed not to, B, disclose confidential information about Topstep, although he agreed not to, C, breach the confidentiality and non-disparagement provisions expressly agreed to in the settlement agreement and affiliate agreement, and D, publicly flaunt such breaches. So, in terms of the whole personal vendetta thing, I am seeing stuff about Michael Patak's wife. So this was a little video that Patrick Wieland posted, and apparently this was Michael Patak's ex-wife.
I'm not really going to bring Michael up because I hadn't.
I'm not really going to bring Michael, meaning Michael Patak, up.
Been thinking about him that much.
I haven't been thinking about him that much.
Because lot of things that I was trying to suppress. I came here to fall in love with Ben.
I came here to fall in love with Ben. Now that's rough. This is also from Michael Patek's ex-wife.
Honestly, that doesn't want to marry me. Like, that's not what I want. Like, I don't want to be with someone, like, I really don't. Like, I wanted to be with someone like you who really does want to get married. Like, that's really, it's, like, really hard for me because, like, I guess, like, I can't do that, but, like, I mean, I'm still going to have to go back and, like, I still can't be with him, you know what I mean?
I still can't be with him, meaning Michael Patek. I still can't believe this is all Michael Patek's wife went on The Bachelor and tried to leave him. Don't be mad at me, bro, that Ben was giving her better dick. Now, that's pretty defamatory. That's pretty defamatory. But he's got some evidence for it, so I don't know if you can get away with that. That's disparagement. That's definitely disparaging. That's undoubtedly disparaging. So, well, I don't want to say undoubtedly. I don't want to give it a... It doesn't look good. You're bringing up the guy's wife, saying that another guy provided better dick. That I think that could be interpreted as disparaging pretty reasonably. But that's not... I'm not giving a professional opinion. Although, you know, the thing about it is it defamation? It's probably not defamation because he's got some evidence more or less indicating that is, in fact, the truth. Is it disparagement? Yeah, it's probably disparagement. This is the exact conduct Topstep bargained to prevent, and Wieland promised to stop when he accepted hundreds of thousands of dollars. For example, in a YouTube video titled, quote, Topstep's Shocking New Rules, released in April 2025, Wieland falsely accuses Topstep of causing him a significant financial loss while at the same time negatively portraying Topstep's proprietary trading platform. Additionally, he admits that his criticism of the Topstep platform, quote, might just be my personal vendetta with Topstep for the rest of my life. They fucked me over for millions of dollars, and now I'm always going to be butthurt. I've spent a lot of time working with that company, and I know a lot about what actually goes on. Similarly, in February 2025, Wieland publicly and falsely accused Topstep CEO of Michael Patek of, quote, always lying, end quote, when speaking about Topstep's programs. Of course, a lie by Wieland himself. Number 6, these and many other of Wieland's public remarks, which Topstep will not further amplify here, have breached the settlement agreement in 2 respects. Okay, so here we get into the actual kind of meat of the matter. First, the confidentiality clause of the settlement agreement prohibits Wieland from disclosing all information, including without limitation, the terms of this agreement, business and financial information, commissions, pricing and sales information concerning Topstep or any of its affiliates partners, provided by or on behalf of any of Topstep's partners, or any other information designated by Topstep as confidential. Recognizing the serious but difficult to quantify harm to Topstep from Wieland publicly disclosing its confidential information, the parties agreed that, quote, each occurrence, this is when you italicize, it's the modern way of emphasizing, each occurrence of a violation of the confidentiality clause would result in $100,000 in damages. While its investigation is ongoing, Topstep has identified over 50 separate violations of the confidentiality clause. So there's a couple of important legal concepts in there that I want to get into. The first is confidentiality is not the same thing as non-disparagement. So these are in fact different. Confidentiality is typically going to go with specific terms of an agreement, specific proprietary information, or things that are just generally deemed trade secrets or marked as confidential. There's a subtle difference here, but it's important. You can have a confidentiality agreement without a non-disparagement agreement. These things are not exactly the same. Now let's get into the concept of, can the parties agree that each and every violation of a confidentiality agreement will result in $100,000 in liquidated damages? So yes, liquidated damages, basically what that means is parties in a contract, and a settlement and release agreement is a contract. They can, in fact, designate if a breach is found by an arbitration or by a court, if there's found to be a breach, this is how much that breaching party is going to be liable for. So you can have liquidated damages as long as the judge or the court, as long as the judge finds that those liquidated damages are reasonable. And $100,000 may seem like a lot of money, but it kind of depends on the sophistication and the resources of the parties, not necessarily reasonable to society at large. So could you see a judge upholding a liquidated damages provision of $100,000 per each breach? Absolutely. I think as long as the parties had an agreement showing that, then I think the court would probably likely uphold that liquidated damages provision. All right, second, the settlement agreement prohibits Wieland from making, quote, any statement or comment that intentionally disparages or damages or could be reasonably considered to be disparaging or defamatory or otherwise casts an unfavorable light upon Topstep, the, quote, non-disparagement clause. The parties agreed that any violation of this clause would result in $100,000 in damages. While its investigation is ongoing, Topstep has likewise identified over 50 additional violations of the non-disparagement clause. All right, so let's talk about disparagement. Is this stuff about Michael Patak's wife? Is that disparaging? Ultimately, that would be up for a jury or a judge in a bench trial to decide. Do I think that so the juries are the finders of facts. So the judge would only determine things like, can you sue in this court? Can you be sued in this court? Does the court have jurisdiction over this contract? Did a contract exist between the parties? Are these liquidated damages bargained for reasonable and considerable? Can a jury find that these liquidated damages could be enforced? Those are questions of law. That's the kind of thing that the judge would determine. Now, determining whether determining what confidentiality was breached, what was not breached, and then determining each and every separate instance, because each and every separate instance a jury could find would be a breach of the non-disparagement clause. So, for example, if the jury would have to decide whether the first post about wife here, the 18-second video, the jury would have to determine, is that the same breach because it's on the same thread, right? Is that the same instance or is it a separate instance? So basically the difference between $100,000 and $200,000. If I'm arguing for Topstep, I'm arguing that each and every post, whether it's a reply or not, I'm going to argue that each and every separate instance is worth $100,000. If I'm arguing on behalf of Patrick Wieland, I'm going to argue that those represent the same instance, right? So a thread is all one thread. So there you go. The one of the things that I have to mention here is, or could be reasonably considered to be disparaging or defamatory or otherwise casts an unfavorable light upon Topstep. So in interpreting that clause, a jury would have to determine, does, for example, posting videos of Michael Patak's ex-wife and saying that whoever this Ben guy was giving better dick, is that in fact casting an unfavorable light on Topstep? I would argue that it could be in the sense that it casts an unfavorable light on the CEO of the company. It's more of a personal attack, really, than a company attack. So those are things that I've been thinking about. All right. So let's move on. Notwithstanding the protracted negotiations between Wieland and Topstep through their respective legal counsel lasting months and the resulting arm's-length attorney-negotiated settlement agreement, Wieland's acceptance of hundreds of thousands of dollars thereunder, and C. Wieland's promise not to violate either the confidentiality clause or the non-disparagement clause, Wieland confessed defiance of the settlement agreement and invited Topstep to file this lawsuit. Quote, I don't care what anyone says. Go ahead and fucking sue me. So let's talk about what that is. In the law, when you make a statement say that you're admitting to a crime, that's called a confession. So I shot him dead. I murdered him. That's a confession. Now let's say we're talking about a civil lawsuit rather than a criminal case. So we're arguing about money. We're in a civil lawsuit. If you make a statement that admits your liability, that's called an admission or an admission of liability. It's not the same thing as a confession, although you can see how those things are connected. Confessions in a criminal context and admission can really be used in either context, but is more closely associated with a civil context. So let's say that this case were to go in front of a jury. Let's say that I'm arguing for Topstep. I'm putting whatever video or written media that statement came in, and I'm using that to my advantage all day long. One thing, I'm not Patrick Wieland's legal counsel, and I don't pretend to be Patrick Wieland's legal counsel. I'm sure that he's got tons and tons of a lot better paid attorneys than me. But one thing I'm sure that they had to have told him was that, that sort of thing is not the right thing to do. Really shouldn't be saying things like that when you're facing, a lot of liability. You're facing a lot of potential damages. So really, I oftentimes advise my clients to remain silent, and I'm almost guarantee you that Patrick Wieland's counsel advised him not to say things like that if he in fact said things like that. But guys, remember that we're reading the complaint from Topstep, from Michael Patak, from their point of view. We're reading the petition. So when the answer comes in, and I'm assuming there's going to be counterclaims, that will give you a better story of Patrick Wieland's side of the story. So we're kind of biased in favor of Topstep right now, naturally, because we're reading the complaint. We're not reading the answer. All right. This is the jurisdiction part. Topstep, originally known as Topstep Trader, is a Delaware limited liability company originally established in July 2012 by Michael Patak. Topstep Trader rebranded to Topstep following a corporate reorganization in 2020. Topstep's principal place of business is at 141 West Jackson Boulevard, Suite 4240, Chicago, Illinois. All right, I'm going to skip through this part. We know what Topstep is. Wieland is a futures day trader and social media, quote, finfluencer. I love that. He's a finfluencer, or finefluencer. I'm going to say finfluencer, finance. Known for producing trading-related content across various platforms, he is the self-proclaimed #1 day trader on YouTube with over 380,000 subscribers, 38 million views, and more than 3,000 uploaded videos to his YouTube channel, which focuses on day trading strategies. You can tell that this attorney is not, in fact, a day trader himself because these are two separate words. It should be hyphenated or just one single word. Prior to his termination, Wieland was a member of Topstep's affiliate program. Jurisdiction and venue are proper in Delaware because the settlement agreement is governed by the laws of the state of Delaware, and each party consented thereunder to the jurisdiction of any federal state court in Delaware. Factual background. Topstep offers a comprehensive platform for aspiring futures traders, combining experiential learning and access to robust educational resources and community support, together with an ability to advance and trade actual capital in live markets. Its structured evaluation process, generous profit-sharing model, and commitment to trader development have solidified its reputation in the global trading community. At the core of Topstep's operations is the Trading Combine, a structured evaluation program designed to assess traders' profitability and risk management skills. Yeah, I don't like that hanging paragraph there at all. All right. Topstep offered select traders with a significant online presence an opportunity to join its affiliate program. The purpose of Topstep's affiliate program was to partner with traders with substantial online presences to help promote both theirs, that should be a possessive, and Topstep's brands. Traders qualifying and desiring to join Topstep's affiliate program were required to sign an affiliate agreement which sets forth the terms and conditions for the trader's participation in the affiliate program. Wieland, a popular futures day trader, met this criteria, as he had established a significant online presence across multiple platforms. As of May 2025, Wieland's YouTube channel had approximately 384,000 subscribers and over 38 million total views, with more than 3,000 videos uploaded. So it's good on Patrick Wieland. It's a lot of videos. In August 2022, this is long. All right, I'm going to skip part of this. In June of 2023, following warnings by Topstep, Wieland's disparagement of other traders. Now I got to read. All right, number 18. Throughout his tenure as a Topstep affiliate / partner, Wieland repeatedly failed to comply with the code of conduct set forth in the affiliate agreement. He misrepresented his trading success to viewers and falsely claimed to have earned, quote, real money while trading in simulating environments offered by Topstep, referred to as trading combines. In fact, records maintained by Topstep reflect that Wieland failed to pass the combine more than 500 times, further contradicting the trading success he publicly portrayed. Such conduct, being completely against the ethos of Topstep and Topstep's intent behind the affiliate program, violated the affiliate agreement, which required Wieland to inform his viewers of Topstep services and new program improvements in order to maintain Topstep's reputational integrity. All right. In June of 2023, following warnings by Topstep, Wieland's disparagement of other traders in Topstep's affiliate program during a live YouTube stream, and his threat to publicly disparage Topstep and Michael Patak, Topstep sent Wieland a formal cease and desist letter. This letter advised Wieland's continued misconduct would result in his termination as a Topstep affiliate partner. This appears to have quieted Wieland's strangely hostile rhetoric for a short while. But after Wieland resumed making false and disparaging comments about Topstep and other traders in Topstep's affiliate program, Topstep terminated him as an affiliate in December 2023 and officially notified Wieland of the termination by letter dated January 12, 2024. Following his termination, however, Wieland's bitter ranting. See, I don't know if I'd be describing things in a lawsuit. It's a little bitter ranting only increased. What followed could charitably be described as an obsessive and false smear campaign against Topstep, its officers, affiliates, and even technology, all delivered by Wieland to his audience in the hundreds of thousands across social media platforms. As part of the settlement agreement, Topstep agreed to pay Wieland hundreds of thousands of dollars for exclusively promoting Topstep services. Wieland agreed to specific non-disparagement and confidentiality clauses that had specific liquidated damages provisions. Specifically, under the confidentiality clause, Wieland agreed to pay Topstep $100,000 in liquidated damages for each violation of the confidentiality obligations under the settlement agreement or the affiliate agreement. All right. Now we have the statement on attorney's fees. Finally, the settlement agreement provides that in the event that a court finds that a violation of the terms and provisions of this agreement has occurred and that a party is entitled to damages, the prevailing party shall be entitled to an award of its reasonable attorney's fees and costs incurred. Notwithstanding his clear contractual promises, this and being paid hundreds of thousands of dollars, you don't need to say that repeatedly, Wieland resumed his pattern of posting and discussing false or confidential information about Topstep. Beginning in January 2025, Wieland's breaches include Twitter and YouTube statements such as "Don't use Project X," Project X shares all the data between all the prop firms now, by the way. You know, Topstep only got to where it is because of affiliates like me and TBM, Trades by Matt. I was bringing in over 10% of Topstep total revenue a month. At Michael Patak, why not disclose your business interest in Project X/Topstep X? Having a stake in a platform that provides data to competitors with ability to monitor traders across multiple firms seems like a massive antitrust lawsuit. Topstep is the biggest dog shit in this industry, being the last affiliate left at Topstep at Coach DBA just getting destroyed every single day on Twitter as Michael Patak makes more bad choices. Come to the dark side, Dakota. Patak will fuck you over like everyone else in the end. Why is Michael Patak always lying? I was a Topstep affiliate, and as soon as I announced that I was going to be an affiliate of Apex, I instantly got cut from the Topstep program. Haha. When you meet up with Patak and ask him how Topstep TV lost $400,000 last year live on YouTube. Guess everyone is getting cut at Topstep. Wieland also shared anonymous text message screenshots stating, quote, Topstep dumped me like trash. I made them a fortune, and now they're cutting all partnerships for very special reasons. It's disgusting. More so on information and belief, Wieland has shared Topstep's confidential information with competitors privately and actively solicited individuals who had appeared as guests on Topstep's platform in an effort to develop a competing streaming channel. Topstep brings this action against Wieland to seek redress for the reputational and business harm his misconduct and breach of contract has caused to Topstep, including the recovery of millions in liquidated damages as specified under the confidentiality clause and the non-disparagement clause, and its attorney's fees. Okay, so here we see the causes of action. The first is going to be a breach of contract, that confidentiality clause seeking the liquidated damages we talked about. The second cause of action is the breach of contract for the non-disparagement that we've talked about. All right. Wherefore, this is the prayer for relief. This is what Topstep is asking for. Wherefore, for the reasons set forth above, Topstep respectfully requests an order, A, determining that Wieland materially breached the settlement agreement as to the confidentiality clause. B, determining that Wieland materially breached the settlement agreement as to the non-disparagement clause. C, awarding Topstep damages exceeding a total of $1 million, reflecting $100,000 per occurrence for each of Wieland's violations of the confidentiality clause and $100,000 in damages for Wieland's violation of the non-disparagement clause. Awarding Topstep its reasonable attorney's fees and costs in connection with bringing and prosecuting this action as expressly provided for in the settlement agreement. Awarding Topstep such and further relief. Okay, so let's take a look at the attorneys involved here. So this is the Delaware attorney. Kind of interested in him. All right, Michael J. Berry. Let's have a look at Topstep's Delaware attorney. And I cannot get the page to load. It's Michael J. Berry. This is what he looks like. Wilmington, Delaware. Chair of the firm's Insolvency and Creditors' Rights Practice Group. His practice centers on complex commercial real estate, insolvency, and bankruptcy-related dispute resolution. Represented the debtors in Art Van Furniture's. Represented the official committee of unsecured creditors as Delaware counsel in the Chapter 11 bankruptcy of the Hertz Corporation. That was a pretty big deal. So I think that was a big bankruptcy. CBD product bankruptcy. represented Pender Capital nationwide in originations, workouts, foreclosures, and bankruptcies. That's a pretty... Yeah, so I would say he's got a pretty big law firm on his side, a pretty high-powered attorney, from what I'm able to see here. Yeah, so I would say he's a top-rated attorney in Delaware, it looks like. Super lawyers, rising stars. These guys are definitely what looks like some high-powered attorneys. I want to give you some thoughts on the petition itself that I wanted to mention. So the first thing here with paragraphs 2, I don't like it when these paragraphs have that hanging, the hanging letters. Let me give you my overall thoughts. Do I think that this lawsuit has merit? Yeah, it does. It definitely has merit. I mean, it doesn't take me 2 seconds to find what I would consider to be pretty disparaging material. So, do I think that this lawsuit has merit? Do I think that it has, a basis? Yes. It doesn't really take me long to find a basis. So, I think there's a basis for this lawsuit. Also, you have to remember that non-disparagement and defamation are not the same thing. So you may have heard before, which is true, that defamation, truth is an absolute defense to defamation. So Patrick Wieland, for example, might be thinking that, his wife actually was stepping out on him and was going on The Bachelor and talking bad about Michael Patak. So therefore it was the truth, and it can't be defamation if it's the truth, but it's still disparagement. So something can be true but also be disparaging. The purpose of a disparagement clause is so that you shut your mouth, even if you're saying things that are not defamation because they're true. So you could have something that is not defamation but be disparaging, if that makes sense. So the disparagement clause is kind of broadly written for any material that may cast Topstep in a negative light. So just by looking at Patrick Wieland's Twitter feed, I think you're probably going to see a settlement come from Patrick Wieland's side. But that's without me knowing the whole story. The disparagement clause does go 2 ways, as Patrick Wieland said. I haven't seen the answer, but if you had to ask me just from the evidence that I've seen from Patrick Wieland's online profile and what we've seen in the complaint and the broad language in the disparagement clause, do I think that there's a basis for this lawsuit? Yeah, definitely. I think there's a basis. So I don't think I would be blowing this off at all if I were Patrick Wieland. All right, that's it for me. Bye-bye, guys. Make sure to like, comment, subscribe.